in this province, the Indian people were never conquered. We were the owners, and Sir Francis Drake recognized that we were the owners at this time. And the following imperial statutes, right up to 1861, all recognized in writing that this was Indian territory. In 1866, the then government in Victoria made the first issue that we were not the owners.
We want to get the settlement once and for all now, not another 100 years from now.
Looking at how we've identified ourselves in the past and coming and eventually tying into the statement of intent that we submitted to the BC treaty process, and looking at some of the earlier maps and then showing the final map that has been submitted back in 1949 based on Wilson Duff's his interviews with a number of elders at that time. This is what he drew to determine the dialect boundaries or the territories of the various tribal areas. This one that was drawn in 1976, Reuben Ware, calls it the main territorial boundaries of the Stalo and other areas traditionally used by the Stalo. So you notice he does go right up to the head of Harrison Lake in this map, goes down to Langley, leaves out the pit area, except it's been recorded here as areas traditionally used by the Stalo. And also the areas used by Stalo kind of goes down into Vancouver or the mouth of the Fraser here. And this is another one by Ware. It's slightly different than the last one because in that last map he says this area here was used and he kind of ended right there. Now all of a sudden look at that, his line goes way up there. And then the other one kind of ended right about here. Now it includes Spuzum Creek. The other map included all of the Coquihalla, and now we leave some of the Coquihalla out. He had this area in Hope Princeton, he had some of that in there, but he's kind of excluded it out there. He still goes down into the States, includes some of the Nooksack, and includes kind of like the New West area, leaves out most of the pit, takes a little bit of the Pit Lake right there, and doesn't really identify the traditional used area as he did in the last map. Like he just says this is Stalo territory and that's it. So this is my first attempt at drawing Stalo territory. And so you can see how I kind of left out this area down here. You can see how I left out the pit, left out the mouth, kind of left out the Nooksack, kind of swung around the Tawasin here. This is the map that was submitted to the BC Treaty Commission along with the Stalo Nation Statement of Intent after the two organizations, the Stalo Tribal Council and Stalo Nation Canada, came together. And now on this you can see the differences now. We have the shared area between Skagit and Similkameen. You can see we include all of the Coquihalla. Gone beyond 5 Mile Creek and follow actually Spuzum Creek. And go up here, upper end of Harrison Lake. All the watershed of the pit. Here's the Pit Lake down here, includes all the watershed. Come down here, and I remember that map that was produced in '49 showed the line starting here and kind of just faded out right here. Right? So now we've drawn the line here. In order for us to comply with the BC treaty process, we needed to identify what our territory is. And we do know that there is differences, like when we look at the Aboriginal right and Aboriginal title. An Aboriginal title is to the land itself, and where rights is usually described as places where you get access to certain things. And even though our title may end right there, just beyond 5 Mile Creek at a large rock in the middle of the river, the late Annie York was saying that rock at Sailor Bar was the natural boundary between the Stalo and the Katmuk. But if you read some of the other oral histories that were recorded by anthropologists, they talk about how Stalo were allowed to go as far as Spuzum Creek. As you can see how the Pitt River is included. We included that whole watershed right there, all the way down to Horseshoe Bay. And the other thing too is that you can see how we stopped our line right there at Horseshoe Bay. You can see how we followed the 49th parallel on this, mainly because we're dealing with the province of BC and Canada. We weren't dealing with anyone from the States, so we didn't bother trying to draw our line down there. It's something we've been talking about for years, but we just haven't got around to doing that yet. We do have Aboriginal right. We may not have total title, or there's going to be overlapping titles or layers of title, but I think we can't give up the things, because we know for a fact that our people used to go down here like that place down at Kate in New Westminster. All of our people up in this area used to travel down there and have access to those cranberry bogs. And I'm not even sure whether or not anyone's even laying claim to those bogs. The last I heard is the cranberry industry is valued at $40 million annually. And we're getting closer to that season right now. And whether or not any First Nations people are involved in that, I don't think so. So it's really interesting when you look at how we're trying to, as a way of unifying ourselves, drawing these lines. And then you can start looking at some of these other lines. They're almost kind of doing the same thing, like they're claiming other areas that they have overlaps with. Like I'm wondering, like why the Tawasin, who are down in this area here, and look at how they go up the pit. I'm sure that's like an extended family line or something, right? I mean, the fellow from Musqueam said he wanted to draw the line all the way to Chilliwack. Maybe that's what the Tawasin did. You know, they had access to this area. So you can see there's all these overlaps, and that's what needs to be resolved. I'm not even sure.
It's going to talk about all of the activities that were going on basically from around 1969 to 1994. This started in 1968 when the federal government at the time decided to send a parliamentary committee around the country talking to chiefs, councillors, and people of the general public. So they did their round of consultations, as they would call it. In 1969, they decided to introduce what is referred to as the white paper policy. The policy was to do two things: take away our special status as Indian people, and it was also to do away with the Department of Indian Affairs. It started a lot of political activity. One of the things that happened in British Columbia is that there was three organizations: the North American Indian Brotherhood, Indian Homemakers Association of British Columbia, and I think it was the Allied Tribes. They invited all of the chiefs of the province to attend this meeting, and at the end of the discussions, when they're talking about the government's policy, of course they objected to it, passed resolutions, and they formed the Union of BC Indian Chiefs as the political voice for all of the people in this province. We, the people of the Stalo tribes, openly and publicly declare and affirm. That's from the original declaration in 1975. So what they did in 1976 was to craft this document in a little different format and presented it to the Union of BC Indian Chiefs, and the Union adopted it as their position. These were the principles that arise from the declaration, and those are some of the things that we still have to abide by. The Department of Indian Affairs was trying to do its consultation, and they set up this group called the Pacific Planning Symposium. We'd gather around there for different meetings and talk about objectives that we want to see accomplished for different programs and services. It went on for a couple of years, and a lot of chiefs made a lot of good recommendations. And then it just died because the department didn't want to do anything about them. In 1982 is actually when they brought the Constitution of this country from England back to Canada. There was three particular activities that were going on before they brought it back to Canada. Patricia and Duran and a number of others from Stalo territory participated with the Constitution Express. They started going across this country from Vancouver, picking up people along the way to demonstrate to the people in Ottawa, the Prime Minister and the Premiers, that it was important that Aboriginal title and Aboriginal rights be protected in this Constitution of this country. Comprehensive claims policy was done in '76, and it was revised in 1981, and it was called In All Fairness. In 1982, the federal government set up its specific claims policy called Outstanding Business. It has to resolve reserves, their problems when they lost reserve lands through rights of ways or through other processes. That's what the specific claims process should do. The federal government set up the parliamentary committee to examine the issue of self-government. The parliamentary committee had as one of its members the late Chief Joe Mathias from Squamish. They went throughout this country listening to presentations from tribal councils, from bands, from people in the general public and some of their organizations as well. The Stalo Tribal Council made a submission to this committee, and used the principles of the Stala Declaration, why we needed to have self-government protected. We used those principles. After all of the presentations that were made, the report was submitted to the government with a lot of good recommendations, and it's referred to as the Penner Report, but it was a parliamentary committee to examine self-government. Right now that report is just in Ottawa collecting dust. As a result of those particular sections that were put into the Constitution, it allowed for constitutional conferences to be held with the Prime Minister and the premiers of the country, and the Aboriginal peoples were invited to attend these particular sessions, and they had it in 1983, 85, and 86. And by the time they concluded those constitutional conferences, there was no Aboriginal rights identified or included in the Constitution in Section 35. In 85, the federal government set up another parliamentary committee to review the comprehensive claims policy. And again, we made presentations to that particular committee. And the report is called Living Treaties, Lasting Agreements. That, again, it's sitting on a shelf collecting dust. Coast Salish were having a lot of meetings because we talked about the force that we could have in making changes to government policy if we got together, and there's 54 First Nations that form the Coast Salish. We finally came to a conclusion that yes, we will try to work together. This Winalmuch Declaration, it was put on a large drum. Most of the Coast Salish chiefs signed it. And as a result of signing this particular declaration on the drum, the thought was that if we ever got to a time when there was going to be treaties negotiated, we would do it as 54 because we had a good declaration together. It was the late Joe Mathias. We were having a meeting in Squamish. He said, if we can't get together on this important topic as fishing, we're not going to make it on anything else. And we didn't. There was a decision made to form the Stala Tribal Council. So 1985, that's when Stala Tribal Council came into existence, and Stala Nation Canada came into existence. And Chilliwack Area Indian Council at the time became the administrative part of Stala Nation Canada. In 1990, we started meeting provincially as the First Nations Congress. It was out of those First Nations Congress meetings that they decided to get the federal government and provincial government together to set up the BC Claims Task Force. They were charged with the responsibility of developing a Made in BC treaty process. So in 91, they came out with their task force report with those 19 recommendations on how to set up the treaty process and what it should do. It was in 1993 when the Treaty Commission opened its doors to accept statements of intent from First Nations to negotiate a treaty. And all discussions we had talked about was trying to make sure that we're going to work together. It didn't happen. Around that time was basically when Stephen was chief of Skokiel. He started talking to myself and Doug and a few others. He said we should get together and try to work on treaty for the people.
In 1991, for the first time ever, Aboriginal people helped set up the treaty process itself. And for the first time, BC treaties will include self-government in the process. And in 1990, the BC government undertook an historic change in policy and agreed to enter into negotiations with First Nations in the province. In October of 90, leaders of First Nations met with then Prime Minister Brian Mulroney and with the Premier and the Cabinet of British Columbia. Those meetings led to an agreement to develop a process for negotiations and to appoint a task force to make recommendations about how such negotiations should proceed. So the BC Claims Task Force was established in December of 90, and it reflected a perspective that negotiations represent the most effective route to articulating First Nations Aboriginal rights. There were 19 recommendations. The report of the task force was published in June 91, and the Treaty Commission was appointed in April of 93. And the Commission, it notes, is responsible for monitoring the progress made and for assisting with dispute resolution and encouraging timely negotiations. There is a 6-stage treaty process. Stage 1, the statement of intent. That's when the traditional territory of a First Nation is identified. Stage 2 is preparation for negotiations. So within 45 days of accepting a statement of intent, the Commission must convene an initial meeting of the 3 parties. And this meeting allows the Commission and parties to exchange information that will be helpful to them in preparation for the negotiations. Stage 3, the negotiation of a framework agreement. And the 3 parties identify what topics or subjects are to be negotiated, the goals of the negotiation process, and then all the procedural arrangements and a timetable for negotiations. Well, Stalo Nation is currently in the 4th stage of the treaty process, as are most First Nations in BC. That's the negotiation of an agreement in principle. This is the longest and most complicated stage of the treaty process. Before it passes, the agreement would be submitted to the Stalo people for approval, for rejection, or for amendment. If this stage is completed, then the process provides the parties involved with the negotiations with the mandate to conclude a treaty. Stage 5 is the negotiation to finalize a treaty. It formalizes the relationship, and some of the technical and legal issues are worked out and resolved at this stage. Stage 6 is the actual implementation of a treaty. It's actually carrying out the treaty, putting it into practice. There are 53 First Nations participating in the BC treaty process, and they represent 122 Indian Act bands. There's 6 First Nations in Stage 2, 4 in Stage 3, 42 in Stage 4, and 1 in Stage 5.
Been in Stage 4 since 1998. In the agreement in principle stage, the negotiations take place on all of the substantive issues identified in the framework agreement. Within Stage 4, there's the big negotiations that take place over each of the issues, and there are also subset negotiations that are based on these principles of IMAs, interim measures agreements. So there's a huge list of issues that need to be addressed as part of this treaty in order to create a treaty, in order to get through Stage 4. So you can understand why provincially there's been such a bottleneck in activity. For one, it requires the full efforts of all the parties involved in negotiation. There needs to be a process for gathering information, a process for communicating information, a process for formulating positions, a process for making recommendations and communicating, as I said, between the communities, through the political and technical wings of the nation, up to the leadership, through the negotiator, and then back and forth between the various parties involved. So in 98 and also carrying on into 1999, we held a series of sessions that included discussions about forestry, forest resources, eligibility and enrollment, subsurface mineral rights, fishing, hunting, wildlife, lands, parks and protected areas. 8 pretty significant and very resource-related issues were discussed there. And those information gathered during those sessions was compiled, information drawn out of them to give to the chief negotiator as the foundation for some of the positions that may be taken within the process. In the fall of '99, Dave Joe was hired on as the chief negotiator. And in December of 1999, we've worked with Dave to develop the Stalo Nation Treaty Vision Statement, which provided a cultural and historical background leading up to treaty, and provided some guiding principles from which to approach treaty as derived from Stalo ancestors and tradition.
I think that looking at the evolution of Aboriginal law through cases gives a better understanding as to why things are the way they are now. Part of that is also just in the context of not having treaties in BC, and the cases have been fighting for Aboriginal rights and trying to establish, what are Aboriginal rights in the eyes of the law. The Stalo Nation has been really instrumental in helping Aboriginal law move forward through case law. Cases do impact the treaty process, but they don't govern it, which is important to remember. The treaty process is supposed to give a bit more flexibility, and they do have a huge impact in terms of the position that people come to at the treaty table, and the leverage and the power that they have in terms of negotiating. Cases also help us look at the role of litigation in land claims and whether going to court is a good option, what other options there are aside from the treaty process. There are the Douglas Treaties on Vancouver Island, 14 Douglas Treaties that were established in the mid-1800s. And then more recently, Treaty 8 in the northeast part of the province that extends into Alberta also. But those are the only treaties in BC, and the Douglas Treaties are very, very small. So the Royal Proclamation wasn't followed in BC. This was a case that discusses the federal and provincial divisions of power. And this case is important for Aboriginal rights and titles issues because it discusses the rights of Aboriginal people as being usufructuary rights, which means that Aboriginal people at that time, the court considered, had a right to use the land and use the resources on it, but not to own the land or the resources. So that was the position of the court at the time, which again conflicts with the Royal Proclamation, really, because the Royal Proclamation established that there should be treaties, and that there should be treaties because Aboriginal people had strong rights. And because of that, in British Columbia, Aboriginal petitions and protests began early on. Aboriginal people were aware that their rights were being infringed upon and not being followed. But the laws in Canada at the time made it also quite difficult to protest because Aboriginal people were barred from hiring lawyers to protect their rights. Potlatches were outlawed, which was an important way of community law. And so it was only later on when those laws were taken away that Aboriginal people really got a strong right to protest and to assert their rights.
This was the section that we insisted to go into the Supreme Law of Canada, simply because it used to be part of the law of Canada that if First Nations had rights, or indeed even if they had treaty rights. And in 1964, this was the law in Canada. If you got a treaty right, that could be superseded by a federal law. So Canada could amend, indeed expropriate or extinguish any of your treaty rights that existed. And clearly that's wrong. Essentially, one, we were here first, and two, if we've got a treaty, that should be respected by Canada, and that if they are to amend or change the treaty through a federal law, then at least they should get our consent. We all joined in various trains and processes and launched court actions across Canada to basically ensure that Section 35 went in the Constitution of Canada. Section 35(1) now currently recognize what our existing rights are, and they recognize treaty rights as well. Once you get a treaty, is that confirmed within Section 35? The answer is yes. And what the process is that your treaty rights become Section 35(3) rights. But the requirement of Canada to amend that treaty is only amendable based upon the terms of the treaty itself. So that if you were to start off with your Section 35(1) rights, clarify them through the treaty-making process to become Section 35(3), the first question becomes, can members of the public attack that based upon the Charter? What happens to the Charter? Does the Charter apply? The Charter is part of the Constitution of Canada from sections 1 through to 34, and by and large conveys the fact that if you're charged with an offense, you're entitled to be heard, you're entitled to call counsel, and you're entitled to equal rights before the law. Now, the problem with that approach is that the Charter is not your value system. That's not your history. as part of any Stalo treaty is that the Crown is going to insist that their history, their value system based upon the Charter applies to you, both in the context of any Stalo lawmaking bodies that you may have, be they band councils, assemblies, etc. They're going to say it should apply to that, as well as applying to any lawmaking authority that you may pass, so that your laws cannot discriminate amongst Stalo, and in some cases, non-Stalo live on your land, then you may have to convey equal treatment to them as well. Like you can't tax their lands more, or you can't charge them a higher form of tax, et cetera, because it's inconsistent with the Charter. At some point in time, we're going to have to decide what our view on that Charter is. The view that I've heard expressed in the past is that the Charter should not apply, or at least stay silent on that point. Section 25 is the section that protects that. It says whatever is put into the treaty, you cannot use the Charter to take away from, detract from what was agreed upon in the treaty, notwithstanding the fact that it's inconsistent with the equality clauses. This is the section that went in 1867 when the provinces in Canada decided to work out a system of lawmaking in Canada, and the question becomes, what happens to Indians and their lands? The provinces cannot touch the exclusive authority that is vested in Canada to run our affairs. All First Nation rights in Canada, be they under Section 35 or be they under a 9124, come under federal authority. 1763 is a document that basically reserves and protects these lands within our hunting territories until there's a treaty. We do have a treaty, and therefore the actions by Canada to proclaim itself as a new state, to the extent that it's inconsistent with what has been agreed in the treaty, is offside. The notorious Indian Act. It first came into existence in 1876. It basically occupies the field for Canada under Section 9124. It sets out all of the basic requirements in terms of matters such as who is an Indian, what is reserve lands, in spite of the fact that we now have common law that basically says that there's no really fixed process to maintain reserve lands. It deals with how we can treat those reserve lands. It deals with our children. It deals with our wills and estates. It deals with schools as to who could go to school. For example, if you look at Section 109, it currently says all children between the ages of 7 and 16 that are listed as Indians must still attend school. And it's this law that essentially forced a lot of us to go to these schools in the past. It's curious to note that that law is still part of the present act. This law, as we know it, is about to be changed by Bill C-7. What Canada is intending to do, determine a code. Every band council in Canada would have to account for its funds in a clear and transparent way. To the extent that you don't adopt a code, that code will be imposed upon you approximately 2 years from the effective date of that law. So they're going to amend that, and secondly, they're going to look at a listing of laws that a band council can pass laws on, and they're going to change that and they're going to amend that as well. And all of this is essentially done without your consent. Canada has a policy. First Nations in Canada can pass laws, and that their inherent right to pass these laws comes from Section 35(1). This inherent right within Section 35(1) is too hard to define. We'll leave it there, but in the meantime, we are asking Canada to occupy the field under their authority, both within Section 35(1), but also within a 9124, pass a federal law that would recognize all of the lawmaking authorities that we think are important. What would be the components? You'd want to ensure, as a principle, that all of the Stalo values and customs are respected and protected. There'd also have to be process within the agreement as well to ensure that either Canada or BC does not infringe upon your lawmaking capacities. There have to be processes to ratify this component of the treaty, and there has to be processes to amend as well, so that the agreement does not solely become amendable by Canada on its own hook. We would define the full extent of what our legal status would be. We'd have a constitutional process as well to define what our rights would be and what that format would be as well. One of the lawmaking powers that we would have would be over our own people. We'd have lawmaking capacity over our own lands as well, be they reserve lands or lands that are retained as part of the treaty-making process. Now, where BC is coming from is the last option. What they want to do is they want to delegate all of the lawmaking authority to the Stalo and simply say, under a law of BC, we will tell the Stalo and all of their people what laws they can pass and what those processes are. And that is a delegated form that has been expressed, and currently that's what we have in place with Canada, because it's Canada that says to our band councils, here's the laws that you could pass, and they express how it could be passed, but it's an occupation of the field by Canada in that respect. Whatever the exemptions are that exist in the past, they should be maintained and crystallized as part of any long-term treaty, so that if we have an income tax exemption, for example, that should be dealt with in a treaty that would ensure that Canada does not infringe upon that. In terms of the court processes, to the extent that the Stalo want to adopt their own court system, they have the authority within Section 35(1), and the Stalo court would have the authority to adjudicate on all laws on Stalo land, so that if there's a law of Canada that's in place under the Criminal Code of Canada, that could go to a Stalo court as well. If there is a law of BC that's applicable on Stalo land, that could go to a Stalo court. And of course, you would have the exclusive authority to adjudicate in respect of your own laws as well. If the Stalos say that all of the lawmaking authority by the Stalos should be exclusive, then it's clear to us that neither BC or Canada could occupy the field. The major problem with that, all of their existing laws don't apply to the Stalo. The second one is paramount concurrent. If we agree on this process, and the Nishka have agreed on this, all we say is that here are the laws that the Stalo would pass. And if they decide to pass them, and if they're in conflict, then it's the Stalo law that would win out. But what that means is that that would force you to pass your own laws. Every year, BC gets a check from Canada for the wealth that is made in Canada, that is made as part of BC in terms of all the people that pay their income taxes within BC here. A check comes back to BC, and it's guaranteed by Section 36. They set out a set of principles as to how the wealth of Canada is shared. Now, as part of the treaty, they have agreed that we would share as part of that as well. It's not to do with any treaty funds. That's our own cash that we have there. But each year, the Stalo and all of the bands as we now know it, or indeed that may become part of the treaty-making process, would get a check to run their programs, to run their band offices, to pay their people, et cetera, et cetera. In the construct of the treaty itself, we probably would have to look to Section 36, look at those principles and determine which of them should be applicable to us, so we make sure that we get equality treatment with BC and with the rest of the provinces as well. To give effect to the full terms of the treaty, the question becomes, how are we going to do this? Do we do Chapter 1 that deals with harvesting before we deal with Chapter 2 on fishing? When do we set up the court processes in place, et cetera, et cetera? Then there has to be a plan as to how we will adopt this to make sure that all of the people who are impacted by the treaty know what's there. These plans are usually prepared before people vote on the term of a treaty. If we have a standoff, what are the processes? What are the options that we could work on to attempt to rationalize these processes? One is that we could go back to the old tried and true national process, and we all know what happened the last time that we had a national process. It was the Charlottetown Accord. We have a BC-wide process. What do we want in BC in terms of lawmaking authority for all of the citizens within BC? Neither BC or Canada wants to pursue principles for a BC-wide process. We can adopt our own table, our own Stalo table, to attempt to articulate the full rights under Section 35(1). And that's currently where we're at as part of that process, because we have not heard of either a BC-wide process or indeed a national process in place.
So there are actually 42 different sets of negotiations that are underway. The treaty process is voluntary. It's open to all First Nations in BC. 34 treaty tables that are in Stage 4, the Agreement in Principle negotiations. And as mentioned, there is one Seychelles, which is in Stage 5.
There's a new bill, Bill C7, that is about to come into effect. I currently think that law currently is offside.
We now have a very new generation, a lot of young people that are asking, searching, and wondering. It's lots to comprehend.